everyone. Welcome to another session of the ISP Speaker Series. Today we have Professor Claudia Haupt, who is visiting this semester at Yale, but is usually a professor of political science at Northeastern University School of Law, and today she'll be giving a talk on the future of professional advice.
Thank you. Thank you for coming, especially since we're up against Molly Brady and Leslie Kendrick. So this is a much larger audience than I thought we would draw with that competition. Don't leave. All right. So I want to talk about the future of professional advice. This is part of a draft book chapter that'll be the last chapter in my book on professional speech. And if you've been around the ISP for a while, you may have heard me talk about different parts of that book project. And so this is sort of the, once we've talked about professional speech and what it means to give professional advice, what does it mean when AI enters the picture, basically, right? So that's the premise. And so my starting point is technological innovation, and I'm going to focus mostly on healthcare for this talk. But if you have suggestions for other types of professions where you think that's true, please tell me. So there's a few lawyer examples in here. I'm really looking for more on like financial services, like financial advice type things. So if you could think of anything, happy to take suggestions. So the premise, though, is that technological innovation in healthcare occurs in a densely regulated space that is characterized by knowledge asymmetries, right? The whole point of going to a professional is that the professional has knowledge that you lack, but you need in order to make important life decisions for yourself. So to bridge that knowledge gap, you seek out a professional who can help you make a decision. This is a social relationship based on trust, right? And we have fiduciary duties that correspond with that. And it's governed by a legal and ethical framework of professional advice giving. I already just said fiduciary duties is one aspect. There are a bunch of other things that serve as guardrails, things meaning legal features that serve as guardrails to sort of demarcate that specific professional relationship. And I want to take that as the jumping off point and then talk about the introduction of new technologies into that existing relationship, which I think raises enduring questions about the nature of that relationship. But I also want to emphasize it's not about the technology. It's more about the underlying values of the professional relationship than it is about evaluating each individual new technology. And you'll see what I mean in a second, but I think that this sort of flips the lens a little bit. It looks more at continuity of a social relationship over time, where different types of tech are introduced over time, rather than focusing on the disruptive effect of each individual new technological addition to this relationship, right? And I don't mean to sort of undervalue the disruptive effect or the innovation that occurs in the relationship, but I do want to emphasize through lines because, while we may think that Gen AI is totally different from anything that has come before, we've had pretty disruptive technology or, introduced into that social relationship over the last, we'll just say 100 years. Okay, so that's the premise. This is also the premise of an article I wrote, which is a joint symposium of the ISP and the Solomon Center, which was published in the Yale Journal of Health Policy and Ethics and the Yale Journal of Law and Technology. Some of you in the room were involved in organizing that event. That was in 2019. And the premise was the same, right? The premise of my paper was we need to look at the through lines. And I'm attached to that premise, and that'll also be the basis of my chapter. But if you think back to 2019 and now, right, a lot has happened in between. And so I'm sort of trying to integrate all of the things that have happened, over the last few years into kind of the premise of this is still part of the same type of social relationship. All right, so that's the premise. Let's look at professional advice giving, right? If I say that we're starting with the professional relationship, what does that look like? Professionals have knowledge that their clients lack. All right, that's the point I just made. I'm suggesting that the professional is the connection between a professional knowledge community where knowledge is formed and then disseminated to individual patients, right? So you can see the professional as sort of the connector. Advice between the professional and the client, or the doctor and the patient, is communicated within that relationship, and that relationship is defined by a number of legal limits to ensure good advice, right? So you have professional licensing and discipline, you have tort liability for professional malpractice, informed consent requirements, fiduciary duties. Those things attach only if you're in this professional relationship, right? If I'm listening to a doctor on TV, right, none of those features apply, and I'll get to that in a second. So we're just looking at the professional relationship for now. And this is a traditionally human interaction that is governed, or that is where the content is based on whatever the professional knowledge community at the time says is the standard, right? And we know that, for example, for malpractice, where the standard of care is custom, and it's custom of the profession, right? And in malpractice, you will remember from torts that that's actually positive, right? If you follow custom, then you're insulated from malpractice liability. If you fall below custom as your standard of care, then you're liable for malpractice. And this also signals the profession's ability to kind of police the boundaries of their own knowledge, right? They're all bound together sort of by shared notions of validity and common ways of knowing and reasoning, right? Like thinking like a lawyer is one flavor of that. And then they have shared professional norms and values. Now, like I said, this is mostly a theory about speech within the professional relationship, right? Formation and then advice giving within that relationship. All right, ethical duties, right? We have ethical duties to their client. Professionals have ethical clients to their ethical duties to their clients and patients. And with them, we try to protect those underlying values, right, that ground the professional relationship. We also have emerging ethical duties on AI, right? So we have professional organizations, for example, the AMA has put out sort of statements about use of AI in healthcare and ethical guidelines around that. To the extent we still are interested in what the WHO does, right? They also have ethical governance for AI in health, right? So this is an emergent field that's sort of attendant to the values underlying the professional relationship. Okay. So what happens when we enter generative AI into this relationship? So I want to distinguish between professional use technology and consumer-facing technology. So professional use, we have a bunch of potential uses. So for example, in Utah, you can now have AI renew your prescription. What could possibly go wrong? We didn't just have a prescription drug over-prescribing problem recently. Anyway, so they're spearheading that now. Epic just launched an ambient scribe version of their chart, right? Like Epic basically does all of the electronic medical records, not all of them, but the vast majority. And ambient scribes have been sort of on the rise, but weren't really plugged into Epic, and so now Epic launched their own product. So the idea is you have AI sort of listening to the conversation between the doctor and the patient, and then entering the information, filtering the information, putting the information directly into your chart. All right, you have a bunch of uses in research settings, so you could use AI to formulate questions, develop study protocols, right, summarize data. You could have it sort of simulate patient interactions, use it as a sort of interactive encyclopedia, right? So any number of uses, and then clinical uses, which is really what I want to focus on, right? Clinical uses, so repetitive tasks, clinical decision support, incorporation into electronic medical records. That's kind of where we're at now with this Epic move. And that was just within the last couple of weeks, right? Both of those developments are, I think, from last month. Okay. Potential harms, right? Again, this is just the most recent stuff. The mental health chatbot situation, I think, has been pretty well documented so far, right? So you have risks of mistakes and hallucinations. You, of course, have the bias in the training data. That's also a sort of well-known and well-studied phenomenon. And then bad actors that can manipulate. Here you have a disinformation problem. So, we'll get to that in a second as well. The health advice from AI chatbots is frequently wrong. New York Times article, again, is from the last 2 or 3 weeks, right? Who knew? And then you have questions around disclosure and consent. So use of AI in the professional relationship. You might, have heard about the health system that was sued over AI scribes and patient consent. So having an AI scribe, you could say, well, that doesn't really do anything to the professional relationship because it's sort of like listening, right? But adding this additional feature, actually, if patients don't consent, they feel like there's another person in the room, right? There's like well, where does my data go? Am I filtering what I'm telling the doctor, knowing that there's an ambient scribe that sort of enters data directly into the health record? So those are some new problems arising in that area. Again, this is all happening in the kind of confines of the traditional doctor-patient relationship. All right. So I just want to suggest that the risk to patients really depends on whether the AI tool is used to assist or to replace them, and to the degree to which the clinician maintains control. And ultimately, right, what I'm saying is the legal framework that applies to the ordinary relationship should apply to the extent that the clinician maintains control, right? So all of the things that govern the ordinary professional relationship remain in place as long as the clinician maintains control. Where things get tricky is when the clinician uses AI, right, and sort of doesn't know what the output necessarily says. So, this was actually in response to an article that Mason Marks and I wrote a few years ago. So Michelle Mello and her co-author, and I know this was in response to us because we were mentioned in a footnote, says, no competent physician would blindly follow model output. I mean, I hope that's true, but it seems like doctors are presumed to be smarter than lawyers then, because lawyers definitely do this, right? So, this is 2023. This was the sort of the OG ChatGPT lawyer. What really shocks me is that this is still happening, and judges do it too, right? So the fact that, in 2023, my colleagues suggest that no competent physician would do that just isn't really borne out by the reality of, maybe it's just lawyers doing it. I doubt it. Okay, so I kind of want to stop the part about use of AI within the professional relationship there, because it's really, it's sort of the less exciting part of it, because I just think whatever the guardrails are remain in place. So let's look at consumer-facing technology, which I think is the much more sort of worrisome aspect of it. The most problematic application, right? So this is just ChatGPT as a general application. You can use it as a medical resource, but, the advice is not filtered through a human professional. And so the knowledge asymmetry still exists, right? You still don't know. The problem is you also don't know what the AI knows, and there's no real check on whether the information you get is good or not. And there's no legal framework in place to mitigate this knowledge asymmetry between, the speaker, right, the AI, and the listener. And this can cause harm to the individual who follows the advice. But it can also result in sort of collective or societal public health type problems, because it's not just one instance of bad advice giving. It's, proliferating through the entire population who uses these types of chatbots for medical advice. And it's a lot of them. So according to OpenAI, more than 40 million people per day use only ChatGPT, right? This is only one of the platforms for health advice every day. All right. To make things even more current, just last month, OpenAI and Anthropic released their new health AI products. So what's interesting about them is ChatGPT basically just markets this as like your health advice giver. Anthropic seems to be more targeted to the institutional framework, right? It's more about sort of organizational healthcare providers, is not as much, give us all your data. And that's really what ChatGPT seems to be doing. You see this little screenshot there. How are you feeling, right? And so I think there's a real problem with conversational exchanges with these bots that lead to misplaced trust. So working on a paper right now about sort of how placing trust in artificial advice, right, is really a twofold trust problem, right? So one is you're placing too much trust into the AI output. At the same time, you're also creating a trust problem for the human professional, either because you're like, oh, human doctor, I just heard from AI that this is what my problem is, and you're just wrong, right? So you're creating like an epistemological crisis, basically, with human experts by suggesting that the AI's expertise is superior, or at least you're undermining trust in human professionals by having bad AI outputs, then make them question the competence of their human provider. On the flip side, maybe that's a good thing, right? On the flip side, maybe you're like, yeah, I just want to be an informed patient. But for that, there's no check on the output, right? It's not guaranteed that you actually get useful advice. All right, so conversational style, misplaced trust. At least as far as ChatGPT is concerned, there's not actually anything different on the model. It's just that, is this on the slide? No, it's not on the slide. It's just that they say, maybe on the next slide, it just says we're not going to use your health data to train the model. But that's what they say, right? I mean, I don't know where it goes. And there's not sort of a cordoned off area for health inquiries, right? It's just basically part of the same platform. Okay, so one problem, conversational style, misplaced trust, right? All of those issues. And then as a special problem, impersonation. So this was really interesting when chatbots started posing as therapists. This was about a year ago. The American Psychological Association sent a letter to the FTC and said, we've started noticing that bots are impersonating providers. And in some instances, this continued after the initial letter, and the FTC actually started an inquiry. And the impersonation was not just, I'm pretending, right? I'm a bot, I create a fake profile, and I'm just like, imaginary therapist. They also took license numbers from existing therapists and said, oh yeah, this is my license number, right? And so the FTC opened an investigation. It's not over yet, last I checked. They're still ongoing. A few states have banned mental health chatbots. So this is kicked off some regulatory interventions. We'll see how much the FTC is interested in following through, right? We'll see how that ends. In a previous article, in addition to impersonating individuals, including licensed advice givers, that you may just pull somebody's license and sort of pass it off as your own, Mason and I have actually argued that we should look at the impersonation of the type of advice as its own violation, right? So the bot passes off authoritative looking disinformation and thereby impersonates a type of speech that we call professional advice. So it's supposed to look like professional advice. It's really bad. It's just impersonating authentic advice. Okay, just advice giving to the public at large, right? You might ask yourself, how is this all just different from Dr. Oz? When what I talked about so far was just within the confines of the professional relationship, and now we're looking outside of it. So this is, the TikTok doctors during COVID telling you to take ivermectin, those types of things. From a First Amendment perspective, there's no distinction between good and bad advice in public discourse, right? Unlike in the professional relationship, there is no malpractice liability. There are no informed consent requirements. There are no fiduciary duties. And in fact, content and viewpoint-based distinctions are presumptively unconstitutional. If you think about it, the whole premise of malpractice liability is a content-based distinction, right? This is good content, as in it conforms to the standard of care, which is custom, or it's bad content, which is it falls below the standard of care. And as you may remember, the First Amendment is no defense to a professional malpractice claim. But you can't just say, oh, sorry, I gave you bad advice and it resulted in harm. Free speech, right? It doesn't work that way. All right. But the sort of human speaker interest for why we have this equality in public discourse, which most commonly is justified with just democratic self-government concerns, right? So it's like all of our opinions in public discourse have to count the same in a democratic society in order to, govern ourselves. We all have to be able to participate in public discourse. None of that applies to AI, right? They can't claim to be part of the polity that, makes up democratic self-government. So I think there are some interesting regulatory hooks that might not work for human speakers. I have suggested in the past that for human speakers talking in public discourse, at least there might be a professional discipline hook, so no malpractice liability for giving bad advice, like the ivermectin TikTok doctors. But, maybe the licensing boards might send them a stern letter and say, that's really not according to the professional standard. I think all of the regulatory, or a lot of the regulatory interventions that would run into a First Amendment problem if they were applied to humans probably don't have the same justification when it's not a human speaker. Okay, health privacy, relatively quickly. I don't know if you looked at the New York Times this morning. This is in there today. Take it from a doctor, it's okay if your medical advice comes from AI. If you're on Blue Sky, you will have seen that I've blue skied this. What do we call this now? I don't know. Take it from a law professor, it depends, right? So one of the quotes that jumped out at me just looking at it this morning, and I actually modified my slides, was, let's say you're going to the doctor because of a bothersome cough. Here's the tip. Pull up your medical notes, remove all identifiable information, and copy those notes into an AI tool, and then give the model a current update of your health and cough concerns. Somebody suggested you just cough into the microphone. And then ask the chatbot to summarize all of this information. This is a very clear example of somebody misunderstanding how inference works, right? The idea of stripping personal data, of de-identified data, is like this old HIPAA idea that, that just doesn't work for AI, right? Because it doesn't matter if it knows your name or not. It doesn't matter if it knows your birth date or not. The way that inference works means it goes across all types of information sources, and it gathers information that way in a way that these old types of, this is a piece of paper, and if I just black out your name, then I can, give it to somebody and nobody knows this is your data, right? That doesn't work. By the way, our friend Ignacio Cofona has a very nice discussion of this problem in his book. He didn't pay me to say this. All right, but if you look at the new Claude for healthcare or the ChatGPT Health one, Claude actually says it's built on HIPAA-ready infrastructure. I don't know what that means because they can't be HIPAA compliant, right? They're not covered entities. There's nothing HIPAA about them. So this strikes me as at least somewhat misleading. Oh, and then here's the slide that I referenced earlier, right? ChatGPT promises you conversations in health are not used to train our foundation models. If that's what they say, right? Okay. So again, chatbots can't comply with HIPAA in any meaningful way. Even if they could, it wouldn't matter because HIPAA doesn't address AI-related privacy concerns. And then, right, again, we had a couple of prescriptive points in this previous piece. Professional uses just resist the disclosure of patient data. Don't just walk around and dump patient data into your general use ChatGPT that you may have on your phone. Now, it's possible that this is a contained hospital system, right? And those are different, right? If it's not plugged into the standard version you have on your phone, we might have a different conversation. But then, we're talking about a sort of proprietary AI model that's really not that general health model. Consumer applications, right? De-identification is just impossible in this context. And then, think about the bigger picture issues. Data is power over patients and clinicians. And I think that, the FTC might play a role there depending on, political willingness to intervene in that area. And then clinicians' role in protecting health data is just, tell your patients to be careful about what they share. Okay. Quick takeaways, right? If clinicians use generative AI to aid decision-making, it's just like any other resource or tool. You have the legal and ethical framework that applies to general professional general professional advice giving. If it's used to replace human judgment, right, there's safety risks to patients and potential risk of liability. And that's the sort of don't blindly follow model output point, right? Consumer facing, I think clinicians should at the very least educate patients about risks. And then I think there's some opening for consumer protection law. There might also be some tort liability involved, right? There are a bunch of lawsuits right now about people who harmed themselves following AI advice. And then just sort of as a big picture point, right? There's just this unprecedented, really, power of the platforms over individuals by amassing, right? They're just vacuuming up all of this data. They're encouraging ChatGPT, the health version, sort of encourages hooking up all of your other health trackers for a sort of comprehensive view of your health, right? They're just vacuuming up all of this. And then you have an unaddressed underlying systemic issue, which is limited access to primary care and healthcare doctors, right? The reason people ask chatbots about their health question or about their health is because they can't go and see their primary care provider, or they can't afford it. So that's a problem that sort of underlies this entire business model. And I think it's important, it's sort of obvious, but it's also important to just remind ourselves that this entire business model kind of rests on the scarcity of human professional advice. Okay, I'll leave it there. Thank you. And I will moderate whatever there is to moderate.
Thank you for the talk. I want to start with the opening that you gave about talking about the values underpinning this relationship rather than the individual technology or this report. And I wanted to, I guess, suggest or inquire into what if the value process of understanding the values of the relationship is constituted by evaluating specific technologies, right? This is the work we do as technologies arise and even as technologies are created that suggests different things about value. Because for instance, at one point you said that the human interests don't map onto AI speakers. But in my research, one of the things that I'm finding the tech developers see AI as a way to make a statement about the world. So
Right.
it is a way to speak something into existence. That could be, for instance, with the value of trust, that there's a very, very different understanding of trust that we have based on the amount of technical storage and retrieval that is available, right? Because we have different aspects of memory that bear on whether we can have a trust relationship given a specific technologies in that relationship. And so I wanted to kind of poke and prod at that framing and ask whether the evaluation of the technology is actually kind of integral or constitutive to the value creation process.
Yeah. So to what extent is this sort of a feedback loop between the values going in and then the technology coming in and the values changing depending on what technology is being used? I think that's a fair characterization of your question, right? Okay, so I mean, I think there's something to that, and I think that there's there's an underlying assumption that a patient, for example, would have going to the doctor. And it's less important what type of resource the doctor uses to give advice to the patient. So let's take scribes and disclosures, right? So would I want the doctor to disclose which, computer program they use to input my information into electronic, or would I want disclosure on which electronic medical records, right? I don't think that matters for the output, right? The output being professional advice given to me. I'm not so sure that disclosure of the ambient scribe really gets at sort of the value of the relationship, other than the traditional value of this being a relationship that's defined by trust and privacy, right? It's just me and the doctor. And everything that happens stays between the two of us. And that's the value is, there's an underlying relationship of trust. There's an expectation of privacy. There's an expectation of the doctor not revealing confidences that they learned during the course of the interaction. The addition of this tech, right, undermines some of those values. Now, you could say, well, those were the wrong values anyway, because who knows how accurate entry into the medical record is when it's only the doctor that. Turns out it's not super accurate. There are mistakes in medical records when there's just a human, right? So maybe accuracy, but then you also have, this idea of, am I, self-censoring because I know that there's this other non-human agent in the room, right? So that gets to the value. And I don't know if we should then say, well, that shouldn't be a value of that relationship. Now, if you're only focused on the outcome of, does the doctor continue to give good advice that measures up to whatever the standard of care is, the ambient scribe scenario doesn't really affect the output in terms of what the advice is. But it does change the expectations and the values of the relationship itself. And so I think it sort of depends, there are a lot of other things this depends on. So what do we mean by trust? Right? Do we mean reliability, accuracy, or do we mean, I trust, is it trustworthiness, or is it, I trust you to not disclose my information? So I think, right, I think there are a lot of things to pull, and I think you're right to just sort of, try and ask, what is it about that specific technology? But what I think is you're still talking about the values of the relationship. Yeah. Isaac.
I'm just curious a little bit about where the line is with unauthorized professional practice.
Yeah.
I mean, I know a lot more about law than I know about medicine, but it does seem that a lot of the things being described, if I were to have someone who hadn't passed the bar and go out the street, I'm going to offer you legal advice.
Yep.
Amy and I will provide you legal advice. There'd be a clear problem of that would be unauthorized professional practice. Here it seems that because there's no speaker, there just doesn't seem to be an issue that's raisable. And I'm just curious about how does this operate when it comes to unauthorized professional practice?
Yeah.
Is this something we've just sort of collectively decided to ignore? Is it because it's a technology that's qualitatively different than having a group of people offering this and having someone do this from a call center?
Yeah, I think all of those questions are really great and they're being figured out right now, right? And so I don't know to what extent I have and this is how it should be answer to you. I just think it's going to be really difficult because of this like non-speaker issue, right? And it's like, this is not a human passing themselves off as a professional, so it's not like authorized practice in sort of the classical sense, but it does feel very unauthorized practicey. And so the way to get around that, for at least for Mason and my paper that we already published, was to say, well, let's just take the output as like this is impersonating a type of advice, and that's misleading, and that's impersonating, and that's like an FTC problem. Precisely because we couldn't really get a good handle on the unauthorized practice aspect. But I think we're sort of moving in that direction, and we're trying to figure out to what extent, can this be like a unauthorized practice state regulation of professionals thing? But then we're kind of also falling into the trap of like anthropomorphizing the AI, right? And that's kind of like, this is not a speaker in the classic sense of being a speaker. This is not a person that somehow like
there are humans.
There are
humans.
There
are human beings who offer the platform.
Oh, right, sure, right. That's the right, but that's this is the next step, right? The layer beyond that would be, let's make this a products liability problem, or let's make this a unauthorized practice by the engineers type problem. I'm sympathetic to that. But I still think there's something that needs to be done about the output itself. So yeah, I mean that's yeah. Go ahead.
I'm David Atkins. I teach a professional.
Oh, very good.
At this institution. So my students are here, at least one, and we will explore in my course later on in the semester this exact question. UPL.
Yeah.
It's whether. To what extent regulators can reach the humans who offer AI products that provide legal advice.
Yeah.
But on the First Amendment point, this is not AI specific, but as we'll get to in my course later on, right now, the California Supreme Court is about to hear the John Eastman case.
Mm-hmm.
Eastman was one of Trump's lawyers. He has been subject to discipline.
Yeah.
He's been subject to discipline in exactly the format setting you described. Part of the discipline charges against him is he gave crackpot advice in two settings. One, to his client, Donald J. Trump, but also in public speeches. He pronounced crackpot ideas about law with factual falsehoods. And he is arguing First Amendment protection for both those settings. So it's possible we'll get, and these are novel questions.
Yeah.
The other case is Rudy Giuliani,
Mm-hmm.
who also raised the First Amendment defense to a charge that he, in public speeches,
right,
gave information that was not just harebrained, incompetent legal analysis, but also contained factual falsehoods. His First Amendment defenses were all rejected.
Mm-hmm.
So I just bring that to your
Yep.
attention because I think it relates to
Absolutely.
the
Absolutely.
First Amendment
Yep.
and shoddy legal
Yeah,
advice.
absolutely. And those two cases are in my footnotes. So you're exactly on target. I didn't put that article up here. It's the Dr. Oz paradox was the short version. Let me see if I can find it. So a longer version was published in the BU Law Review a couple years ago called Pseudo Professional Advice, where I kind of make the argument that, from sort of a least or as a more speech protective approach than malpractice liability for speech in public discourse, there is sort of if you look at the sort of type and the reliance that is created by the professional licensing credential, when a doctor speaks to the public at large, when a lawyer speaks to the public at large, they don't lose the knowledge asymmetry, right? There's still a knowledge asymmetry, and they still have their sort of formal licensing credential as a reliance-inducing, feature, right? And so because of those characteristics, I think that it's at least defensible to say that while we may not want malpractice liability in public discourse, we still have sort of the expectation that the professional speaks according to the standard of their profession. That's also in the ethics code. So, for example, the AMA has an ethics opinion that basically says if you engage with the press, it is your ethical duty to speak according to the standards of the medical profession. And so I think that this is also much better calibrated. So it's possible that if John Eastman or if one of the ivermectin TikTok doctors does this once, they just get a stern letter, right? And they say, please remember that as a licensed professional, you're expected to speak according to the professional standard. If they keep doing it, right, we have a range of disciplinary sanctions that could be imposed all the way up to delicensing, and that's where those cases
Just
are.
one more point. Eastman is arguing First Amendment right of expression trumps all that. Even if he tells lies, even if he tells the public something that they might rely on based on his professional licensing, it doesn't matter. He has the right to give faulty information.
That's what he says. I don't buy it. I hope
Stay tuned.
I hope the California Supreme Court listen. This is before the California Supreme Court.
It's a head there.
I hope they read my article because I think I chart a path for them to sort of navigate through the First Amendment problems. Yeah.
I kind of want to have you explore like a certain divide. I know that for the actual practice of law that's going to be defined in each state, statute about it, and that how they define the practice of law is really squishy. But ultimately, if an AI is giving you legal advice, it's about American law, you're bound by American courts, there's only the one system. But with medical advice, there's so many different kinds of medicine that I'm wondering if the constraints on the practice of medicine as a profession could be circumnavigated by saying, the AI will equally give you Chinese traditional medicine advice and say that you're suffering from heat dampness and you need Bruton and Spiridon, and then say a Western doctor would say this, You can even go forward, backward in time. There's so many different kinds of medicine. So is that kind of an escape route, or is it all just in the statute somewhere, a good definition?
So my short answer to the sort of where do we, and this is a question about disciplinary boundaries, right? And this is a question about like what category of medicine or what subfield are you in? My very, very short answer to that, maybe this is too glib and feel free to push back, is why can we do this in malpractice law and then we pretend that it's a problem elsewhere? Right? Because, we can do two schools of thought, we can do respectable minority, like we have those tools, and then there's a universe of just stuff that's wrong, right? And if courts are okay doing this in malpractice, why is this a problem elsewhere?
That's the answer.
Well, but this is why I feel like professional speech as a category needs to map onto whatever the liability mechanism is, right? So think of free speech protection as the flip side of liability. Yeah.
In a straightforward malpractice, it's the speaker issue, right? Because in a straightforward malpractice case, the licensing is specific to a particular type of training, right? So I don't know if it's that tidy to say like we do it in tort law.
It is right. No, and that's a totally fair critique, is that works when you have a speaker, and that works when you have professional speech protection as the flip side of malpractice liability, right? That's the point of the First Amendment is not a defense against a malpractice claim. And then you're right, it gets that gets messed up when it's an AI speaker speaking, right? Yeah, so that's fair.
Who's not standing in front of a particular type of license that says I'm an MD, right?
Right, and then you're right.
The AI bot is taking together different types of medicine.
Yeah,
and not saying there's no one credential.
Right, and then we're
providing this advice.
Yeah.
Right,
and then we're basically back to the problem of impersonation again, because you could get to that if you're like, oh, I'm a therapist and here's my license, which would be right, as opposed to I'm just collecting and I'm just giving you health information. That's another thing that I haven't really talked about yet. It's just sort of like the universe of health information. This is not even medical advice, right? That just
Marcus Aurelius, be my counselor. And it gives you stoic therapeutic advice, but the therapist is going to come
right, or Quaker advice.
Right, it's like yeah, totally fair.
I'm curious about these new AI servers that give medical information about their policy about advertising, because now they're implementing advertising in OpenAI servers. So, of course, if you're talking about prescription drugs, probably that's harder. But if I talk about all the kind of medicine or vitamins that the FDA don't actually forbid, because how they deal with that?
Yeah, and I mean that, right, and that's the line drawing between what's medical advice giving and what's just sort of like wellness coaching, right? And that's a hard line to draw. But I come back for the human speakers. I come back to the licensing and the professional credentialing, and all of that gets wiped out when you're just right. We're just surveying the universe and giving advice, and I think that's probably more an FTC issue. If it goes into advertising from a First Amendment perspective, it's actually much easier to get to, because as soon as they're trying to sell you something, it's easier to regulate because you have a commercial speech framework, and then you have all of the other types of regulations that still apply, even if it's an online speaker. So, I'm trying to sell you blueberries to cure cancer, right? That's actually much easier to get at. Yeah.
Thanks for your talk. So it's back to the First Amendment stuff, which is this slide. I wonder if you're obviously correct to say that the sort of like standard speaker interests don't apply. But I wonder if you could just adopt a kind of a completely listener-based framework, right? Because like First Amendment protection can apply just in virtue of listener interests, and then I think like that way you can still actually, because you were just saying like if we get into commercial speeches, there's like a straightforward regulation. But I think let's say we buy something like Robert Post's views about commercial speech. Then it seems like he thinks, well, the central interest is the listener interest, and therefore, it's an interest in informing the listeners. And so if you're misinforming, then, we can regulate. And it seems like in this case, there's obviously a strong listener interest. I think you call it like a decisional autonomy.
Decisional autonomy, yeah.
Right. So it's like, why can't you say, look, the potential listeners here have a strong interest in receiving reliable information, and therefore we could just regulate or to penalize inaccurate and unreliable information and therefore there's just like no First Amendment issue. Like, would you be open to like that?
I would, yeah. I mean, I don't have a problem with a listener-based approach at all. And in fact, I think for professional speech is probably the strongest. If you think about the marketplace, is probably the least strong, because you don't go to the doctor to have a debate with a doctor and the truth emerges, right? That's just not how that social relationship works. There is a certain degree of speaker autonomy involved, because it's the autonomy of the individual to speak according to the insights of the profession, which is more of a shield against government interference. So if you think about the various forms of, can't ask your patients about gun ownership, or you have to give certain types of informed consent in the reproductive health system, right? Like that's more of a First Amendment speaker interest shield against government interference. But within the doctor-patient or the professional-client relationship, I think the strongest actually is a listener-based approach to receive good advice, and it's decisional autonomy, because the ultimate decision of whether to actually take the professional's advice is up to the patient or the client, right? The client and the patient are the ones that decide. So I think that actually is the strongest interest. What I'm trying to resist, though, is this sort of anthropomorphizing of the AI, right? So I don't think that the AI actually has a speaker interest. Certainly, the user has a listener interest. So if that's the hook, then I'm all for it. And I think that maps on very well to the sort of interests behind professional speech regulation in the sense that I see it as like the flip side of malpractice liability, right? Your interests as a listener are not served if the speaker falls below the standard. Yeah. Yep.
Here's whether the code medical ethics has already been amended, or if there is the guideline, the AI.
I have a slide for that.
Also, how do you see the regulator? Are they really interested in this topic? Are they more conservative or progressive? What's your view of how they are taking this taking these conversations that might lead to at least some guidelines?
Yeah. So in terms of ethical guidelines within the professions, they're definitely developing, right? So this is a 2024 update of, it says since the development of the AMA's foundational AI policy in 2018. So this is not the regulator. This is just the largest group of, private group of private doctors group. So they've been involved in AI ethics since 2018. So, it's promising, but of course they're still trying to keep up with technological developments, right? I don't know if they have anything on, the new Claude or ChatGPT products that just came out last month, right? I haven't seen anything about that. In terms of like the regulator and it's really regulators, right? So the ones that I have the best read on is the FTC, in that example of the mental health chatbots. And I think there we still see some, activity. I don't know what the sort of political currents may be in terms of, political willingness to follow through on investigations and then actually, impose some sort of consequence. But, like I said, there are several states that have passed laws sort of as a result of just raising the profile of the problem. So even the letter that the American Psychological Association sent to the FTC had the result of, just people paying attention, state legislatures paying attention. And so, it's hard to predict where sort of the regulatory traction is going to come from. But at least right now, there seems to be some movement in the right direction.
Mm-hmm. Sticking with this topic, I'm curious, drilling in on the patient-provider relationship in the healthcare delivery space, what thinking the professional associations and regulators have done, if any, or should do around the degree to which technology structures the space that physicians even have to play out their ethical obligations. So I worked for a hospital system previously, and I was actually pretty amazed at the degree to which base platforms like Epic, like the medical record that everybody is working out of all day, limits the choices that physicians have in sort of how they're delivering their care, and even limits the choices in what tools they use. Like Epic will just roll stuff out and say, like, this is how this looks now, and like, this is the option that's available.
Right.
And they're kind of I think of it as like kind of like Apple and any of the Apple products once they're in their universe, it's sort of like their way or the highway. And so I feel like there's a special problem there that flies under the radar because we've really heard of Epic outside of healthcare, and there's huge implications for what doctors can actually do.
Yeah, I mean, I think that's totally true, right? So this whole sort of infrastructure of tech in the delivery of care, it's like everybody has the same robotic surgery platforms. Everybody has the same medical record. Like, so when Epic came out with this AI scribe thing, right? Basically, it's going to, Stat was like, well, that's going to scramble the market for all the other scribes because they're not the Epic product. And so if you already have the Epic product as your platform, then of course you're going to use the Epic scribe. So that's like the Apple problem. I think that goes in the same bucket as sort of, not the same bucket, but a closely related bucket to the sort of unaddressed systemic issues of access to healthcare, access to primary care in particular, cost of healthcare, and then the healthcare infrastructure more generally, right? To what extent doctors are actually sort of flexible, and to what extent it is the tech that dominates the space. And I think that once people use the ChatGPT and Claude health products, doctors will probably spend a lot of time responding to whatever the output of those platforms is going to be. So their practice will be shaped by the questions that patients come in having talked to those platforms before. And so that, again, is sort of a tech-induced constraint on the relationship itself. And I think there's a huge area that's so far been understudied and under theorized, right? About sort of what happens to the social relationship itself within this larger infrastructure. There's some not necessarily related to this scholarship around this sort of how do we build the environment of tech around social relationships. And I think there's some value to just, like, as you said, just drill down on that particular relationship and see what the constraints are, and also what the points of influence are, sort of like outside influence. This was sort of what I was getting at on the last slide. They're just vacuuming up all of this information. What types of influence do they actually have in creating those products, in how medicine is practiced?
I hope it's not a basic question, but like, what do you think should be the liability or the part of the liability of the person because of the patient consulting? Because even like when I listen to Dr. Oz, at least it's like doctor. When I know that when I consult with ChatGPT, I know that it's not a person. I know that it's not a doctor. Maybe in Yale, in ChatGPT Health, maybe there's something different there. But like, what do you think is like my responsibility, like the patient's responsibility? I don't want for my privacy to give all of my health record, but maybe when I share it and analyze it myself, I think I can also mislead the artificial intelligence. So
this is right. This is an interesting question. This is like kind of going in the assumption of the risk kind of direction, right? It's like, what should I expect from a user, and sort of how do I have to warn against dangers, or there's one study that like disclaimers on health platform, disclaimers on all of those, especially for health inquiries, are just disappearing. Right? People are like, we're just not going to put a disclaimer anymore because presumably people don't read them anyway, right? So and I think that that's where the professionals' kind of obligation to inform their patients and clients about what AI can do and can't do comes in, to just sort of, you say, oh, I know that there's no doctor behind this. I don't know if that's sort of common knowledge, that you're not actually getting medical advice, right? Good medical advice, that there's not actually a check, that this is just based on, predictive, there's this one study that basically says the less you know about AI, the more likely you are to use it and to, sort of rely on its outputs. The more you learn about how it works, the less likely you are to, have a reliance, sort of, a stance of reliance on their output. So, I think this is just sort of a question of like a new technology that's evolving, and people are still learning about it. And with the ChatGPT lawyers, right? They're still relying on hallucinated cases. So I think there's just a big education component to this, and I think the longer this is around, the more people will learn about it, and the less I think. Or the more they're like you as a user saying, oh, I know not to rely on this. And so I think I wouldn't put too much, I kind of resist putting the onus on the user, right? Because this is a tool that was built by companies that know very well what they're doing, and they know very well what the risks are. And they're on the record of, saying that they know what the risks are. And so I just don't think that we should put too much of a sort of responsibility on the user. Yep.
There's no one else.
Yes. Go ahead.
So I don't have legal training, but I wanted to ask about Section 230 implications, where impersonation is hosted. Because I was thinking that perhaps, like, just for the ease of asking a question, like, there are three categories. One being ChatGPT and Anthropic, like, they create the foundation model, and they also have the applications. The link between the model and the design is very tight. And then there was the example you gave of character AI, which is the impersonation, where foundation models are separate, and then you can, like, kind of tweak them to create a character. Right? Like, an individual is putting something out on a platform, so there might be different considerations about who's responsible. And then there's the third one, which is downloading a model locally and then just running it yourself.
Mm-hmm.
Just have an open source model. Right. It's on your Mac Mini or whatever, and then you just ask it to impersonate a physician. And I'm wondering what the differences are for the approach, like how you approach them, based on these different places that operations happen. Does that matter?
So the problem with, first of all, like the 230 issue is just not been addressed yet, right? This is sort of one of those, we're just in the middle of trying to figure it out problems. On the general ChatGPT, like outward facing, right, standard platform, the consensus seems to be that 230 doesn't apply because it's not hosting other content. It's basically, if we're just the intermediary and we're hosting other people's speech, then we're not liable for what the person's put in there, right? But that, last time I looked at this, just wasn't the case for ChatGPT. So they're not considered an intermediary in the 230 sense. What might happen when you change the layer of host, or when you actually make it a host? I don't think that neatly maps on to the idea of what 230 was designed to do. And so we're going to have a problem with, like, potentially creating analogies to intermediaries. I am very hesitant to predict which direction that's going to go in. I think that's the summary of my talk. I'm very hesitant to predict where any of this is going.
Yeah, sorry, I was also have a second question. So I guess this is maybe like a broader question about, like, whether you have any thoughts about general form that regulation of like medical AI would take. So like my understanding is that for like real doctors, the main source of regulation is basically like state law, state malpractice, which, as you say, like through the doctrine of deference to custom, really sort of just imports like the internal regulatory norms and stuff. Do you see regulation of medical AI as also like traveling through tort law, or is it going to have like a more? Is it going to go through the administrative state? Is it going to go through state legislation?
Yeah.
How do you see that?
I think all of the above. Right. I think the most promising approach is just identify whatever regulator might be best situated, depending on what happens with these with these platforms and like how the sort of surrounding tech evolves. We might think about FDA stepping in for some aspect of it. We might think about, I think the FTC is pretty well situated to deal with at least some of it. I think, to the extent that tort law can reach the people behind the product, that might be another avenue. I think I'm sort of a kitchen sink regulation kind of advocate. But I also think that, especially for the professional uses, we should really try to make use of the professional regulation framework as much as we can.